Hello, everyone. This is Joe Gentile from Sarraf Gentile LLP. And today's topic or today's question is, who has standing to sue in federal court to challenge an unreasonable immigration delay or denial? And for those of you that don't know, standing is basically just a fancy legal way of saying who can be a plaintiff to file a lawsuit. If in the immigration context, if you are one of those people that self-petitioned, then this is very simple. You have standing to bring the lawsuit. Where it gets a little more complicated, and this is the more common situation, is where you have a sponsor and you have a beneficiary. So in every instance that I'm aware of, sponsors have standing to bring lawsuits to try to get an immigration benefit, which is to have their beneficiary come to the US, stay in the US, be able to work, whatever it may be. Where the law is split is, do the beneficiaries have standing to bring lawsuits without their sponsors? The majority of courts say that beneficiaries can bring cases on their own, but there is a minority that says that they don't have standing to bring a lawsuit. So in general, the most prudent strategy is, for whenever possible, is for the sponsor and the beneficiary to both be plaintiffs in the lawsuit. This way, standing is just not an issue. However, sometimes sponsors are reluctant to be plaintiffs in lawsuits. This comes up more in the employment context than it does in the family context. Normally, if you're petitioning a relative, spouse, whatever it may be, if there's a problem, the sponsor is usually very willing to be a plaintiff in the lawsuit to address the issue. You get a little more hesitancy with employers. Employers sometimes just don't want to get involved in litigation, and sometimes they're worried about potential publicity. There are steps that lawyers can take to try to address those concerns. For instance, you can put the beneficiary's name first in the caption when you file a lawsuit, so that if the case gets reported, it gets reported with the beneficiary's name. And also, just in general, immigration cases, while they are public, it's publicly available, information on the cases is a little harder to find than for a typical civil litigation. So if somebody is intentionally looking for it, they're going to find it, but it's not the type of thing necessarily that's easy to stumble across, particularly if there's no reported decisions with the case. And also, generally, these are not high-profile issues. Your typical litigation for a delay or denial in the immigration context is not going to end up on the front page of the Wall Street Journal. It usually doesn't get a lot of attention. But in the instance this is not persuasive for an employer, then, as I said before, you have to look at the jurisdiction for where you're filing it, but most of the time, albeit with a little more risk, you can file a lawsuit with just the beneficiary as a plaintiff. So that's today's video. As always, thank you for watching. Feel free to reach out if you have any questions you'd like to discuss with me, and I encourage you to subscribe for future videos. Thank you very much. Have a great day. Bye.